From a former Clark County Sheriff's officer being sentenced to 60 days in jail for violating bond conditions and offending the judge with his actions, and later receiving a 12-year prison term, to a Michigan State police officer arraigned on charges of second-degree murder and involuntary manslaughter, here are 5 times evil cops were instantly owned in the courtroom, starting with the shocking contempt ruling in Clark County.
Do not try to deceive me, defy me. You will not like the consequences. Today is that day. Take him into custody.
This is former Officer Jamie Knoll from the Clark County Sheriff's Office. In April 2024, Officer Knoll faced the court in a case where multiple firearms were discovered in his residence. The discovery of the weapons was a violation of the bond conditions set by the court, and therefore he was found in contempt of court. Officer Knoll was originally arrested on November 8, 2023, facing 15 felony charges, which included theft, official misconduct, corrupt business influence, ghost employment, and obstruction of justice. Witness the judge's intense reaction as Officer Knoll is found in contempt of court.
I told Mr. Knoll, don't do anything stupid. Do not try to deceive me, defy me. You will not like the consequences. Today is that day. You are not the law. You don't interpret the law. You don't enforce the law. You're not above the law. I find that you are in contempt of this court. Take him into custody. No, that's enough. I'll find you guys in contempt for disrupting the proceedings, and you'll be there right there with him. Now, what is an appropriate sanction? The question is, I can sentence him up to 180 days without a trial, or I can sentence him to a day, or I can release him. You know what I think the answer is? 60 days in. That's what I think the answer is today. Now, Mr. Wilder.
Yes, Your Honor.
Or Mr. Voiles, I apologize, Mr. Voiles, your lead. Before he is released, I'll take your suggestion. I want an independent individual to scour that household to determine that there's no further weapons. I find that Mr. Ertl's original argument that he was trying to make that I sustained, an officer of the law, every time I go into court, I hear, I didn't know it was there. I didn't know it was there. I really didn't. You've heard that a million times. You've heard it a million times, and yet you still take them into custody, would be my guess. Every officer in the world has heard, I didn't know it was there. It's my friends. I'm not buying it. It was your burden. It's your responsibility. And today, the court will enforce that. Take him away.
The judge looked clearly offended by Officer Knoll's actions. He then carefully deliberated on the appropriate punishment and ultimately sentenced Officer Knoll to 60 days in jail. Furthermore, the judge mandated an independent inspection of Knoll's household to verify the absence of any weapons. He rejected Officer Knoll's defense at first instance, which relied on the common claim of being unaware of prohibited items. The judge firmly then emphasized that the responsibility rested squarely on Officer Knoll. He was taken into custody there after the discovery of firearms. Later in August 2024, he was sentenced to 12 years in prison after he pleaded guilty to charges relating to corrupt business influence and theft. If you think this was the only evil cop who got owned in the courtroom, wait until you watch this next case.
I do agree that a personal recognizance bond is appropriate. I am going to set a $250,000 personal recognizance bond in this matter with standard bond conditions.
This is former Officer Brian Keeley from the Michigan State Police. In June 2024, Officer Keeley appeared in court after Officer Keeley was arraigned on charges connected to the death of Samuel DeJean Cornelius Sterling. The charges, including second-degree murder and involuntary manslaughter, stemmed from a vehicle-related incident on April 17, 2024. The judge's questions focused on ensuring Officer Keeley understood the charges, confirmed his plea, and addressed his legal and procedural rights, including the waiver of time guidelines. Additional questions evaluated his background, criminal history, and arguments related to the bond. Watch how Officer Bryan and his attorney respond to such questions.
Does he have grievances in his record? What does his record look like? You're telling me that there are no prior instances of this nature in his history?
No, I reviewed his personnel file, Your Honor. I talked to the people that know him. There is no grievances in regards to excessive use of force at any other point in time. Any motor vehicle accident, to this point, as a matter of fact, he received the Gold Award from the Michigan State Police for having 12 years of accident-free at-fault accidents and operation of police vehicles. He is a man of faith, attends church regularly, and he is not a person that I am concerned that is not going to appear or is a danger to anyone.
And how long has he been on the force?
He was a trooper for 25 years. He was 26 at the time that this happened.
He resides in Grand Rapids?
He resides in Ottawa County. We were going to correct that with the court once we were done this morning.
I do have a Grand Rapids address on file for him. And so the things that the court considers are risk to public safety, willingness to appear and stand trial, prior criminal record, and as it is Detective Sergeant Keeley turned himself in willingly, does appear willing to appear and stand trial in this matter, has little to no criminal record, and certainly nothing that leads me to believe that there is a risk to public safety that is representative of the conduct alleged in this matter. I do agree that a personal recognizance bond is appropriate. I am going to set a $250,000 personal recognizance bond in this matter with standard bond conditions. I understand he is suspended from his duties at this time.
A little bit of limbo as to where he has filed for his retirement. The Michigan State Police have released to the media that he has retired from the department, but he was suspended without pay up until the Michigan State Police made that announcement to the media.
And so while this case is pending, you may not leave the state of Michigan. You must update your address with the court and then continue to keep it current with the court. You may not, of course, commit any crimes while on bond, and you must show up on time for your court appearances, which are...
Keeley, you lucky because she's a good judge. That's the only thing I'm saying. You lucky. She's a great judge. Great, amazing. But you?
Thank you, ma'am. June 17th at 1 p.m. is your probable cause conference date. June 24th at 2 o'clock in the afternoon is the date currently set for preliminary examination. Anything further in this matter, counsel?
If I may, Your Honor, given the facts and circumstances of this case and the charge, in discussions with the AG's office, they were expecting me to ask the court if we could enter onto the record a 21-day waiver at this point. So if there is an adjournment down the road, we don't have to worry about putting that on the record at a later time.
And the law and court rules do require that the probable cause conference and preliminary examination be set within certain time guidelines. Mr. Keeley, I'm certain that your attorney explained those to you. Are you voluntarily waiving your right to have those hearings held within those specific time guidelines?
Yes, I am.
And then we will enter that waiver onto the record. Are you asking to have either or both of those moved at this time?
I think we can do the probable cause, Judge, and let me talk to the prosecution, and then we'll be able to determine whether or not we'll be able to go forward on that date.
All right.
Officer Keeley pleaded not guilty to all charges and was granted a $250,000 personal recognizance bond with standard conditions. These conditions included restrictions on leaving the state, requiring him to update his address with the court and attending all hearings. The court emphasized the seriousness of the charges and imposed stringent bond conditions accordingly. The case is still ongoing and has not been concluded yet. If you think this was the maximum evil cops can get instantly owned in the courtroom, then you probably haven't watched this next case.
And so to the extent that Officer Massey used force that was not necessary, this force was non-trivial and violated Ms. Mina's constitutional right. And because this was clearly established in 2016, as it is today, we respectfully ask this court to affirm if the court does not have any further questions.
This is Officer Massey from the Tucson Police Department. On January 22, 2020, Officer Massey's attorney was attending the court hearing where he faced severe opposition from his counterpart, who is just a young law student. Officer Massey employed excessive force by shoving a woman's face into a palm tree during an arrest. The case focuses on the legality of the officer's actions and whether the use of force was excessive and unconstitutional. A young attorney has challenged Officer Massey's qualified immunity, arguing that the officer's actions crossed legal boundaries.
May it please the court. Good morning. My name is Damian Gallagher, and I'm here for Ms. Mina, the appellee. I'd like to start at the point that Judge Malloy noted that this case is coming down to whether it's a pine tree or a palm tree, and that simply is not the law within the Supreme Court nor this circuit, as it was clearly established in 2016, as it is today, that an officer may not employ non-trivial force against an individual who is not resisting arrest nor passively resisting arrest.
So how do we determine whether it's non-trivial force? Is it, can we look to the injuries? Is that determinative or is it not determinative?
Your Honor, in evaluating whether or not the force is trivial or non-trivial, it of course is a reasonableness inquiry under the Fourth Amendment, but typically in the excessive force context, it's evaluating whether or not that force was necessary and the degree of that force was necessary in effectuating that arrest. And here it was non-trivial because Officer Massey had Ms. Mina within his custody when he was handcuffing her, and once he pinched his hands in the handcuffing, that's when he retaliated against her by thrusting or shoving or whichever verb this court chooses to adopt, and threw her into a tree where, as this court has noted, she was bleeding and had scrapes on her face and shoulders. They were investigating tax fraud, I believe, which this court classified as nonviolent. And so, yes, Your Honor, it could be a factor, but because here, at most, it is a misdemeanor. But one, we do believe that Ms. Mina didn't violate this law, and Officer Massey in his deposition admitted that he never asked her for her name, he only asked for her ID, and therefore not even violating the law. And so to the extent that Officer Massey used force that was not necessary, this force was non-trivial and violated Ms. Mina's constitutional right. And because this was clearly established in 2016, as it is today, we respectfully ask this court to affirm if the court does not have any further questions.
Okay, thank you very much. I do have one further question, and this is for the courtroom. You're a law student?
That's correct, Your Honor.
And where are you a law student?
I'm a third-year student at William & Mary Law School.
Okay, thank you very much. And we would like to compliment you on the quality of your presentation. I'll compliment you too, but you do this for a living.
Yeah.
So,
okay. Thank you, Your Honor.
Thank you. 2 minutes on the clock, please.
Very quickly, Your Honor. He mentioned Gravela and Meredith, both bystander cases. I just want to make clear. Gravela itself said there's a difference between a bystander and someone who is, quote, integrally involved in the volatile situation to which officers were responding. Meredith.
I'm with you. I agree with you on that. Although, again, I guess I just asked you the question. She's charged with not showing her ID. That seems pretty low on the totem pole. Maybe not a bystander.
Right.
But maybe one step above a bystander.
Sure, but they're investigating possible domestic violence and underage drinking.
Not from her.
She's on the median with Taves.
No, but or they suggest. Oh yeah, I see.
When they go to the median and need to get her off the median, those are the crimes. I would just very quickly, Your Honor, en banc case called Matos v. Agarano that this court has decided, where domestic violence is. The volatility of those situations is recognized, and the great danger of them is recognized. So this is not just she didn't show ID. There were serious matters to be looked at. I'd also mention just Parker, that Parker only said in 2018 that a shove would not be, there was nothing to say it would be a constitutional violation. Clearly in 2016, that's also the case. So we're always back to this second prong, and that's where we think we win. I will finish with simply saying I also want to compliment my opponent for his argument. We think the evidence, if you look at Mena's testimony, there is no case law that says there was a constitutional violation here that would have put the officer on notice, and we ask that you reverse. I simply want to say that however uncomfortable I was, I enjoyed our colloquy. Thank you.
Thank you. Thank both sides for their very good arguments. Mena versus Massey, submitted.
The court ultimately denies qualified immunity for Officer Massey, and the young attorney's presentation is praised for effectively presenting the case. Officer Massey's use of force was deemed excessive and unjustified. His legal arguments were seen as weak and insufficient in countering the compelling evidence presented by the victim's attorney. The judges ultimately found his actions to be unconstitutional. If you think this was the height of evil cops getting instantly owned in the courtroom, then you probably haven't heard of this next case.
And you had your gun drawn the whole time you were giving commands, right?
Once I started ordering him and he refused to show me his hands, yes, it escalated where I pulled my gun, yes, ma'am.
And he was awake, correct?
What's that, ma'am?
Mr. Floyd was awake. Was he awake during this incident?
Yes.
He was conscious?
Yes.
This is Officer Derek Chauvin from the Minneapolis Police Department. In April 2021, Officer Chauvin is answerable to the court related to a case that unfolded on May 6, 2019, involving an individual named George Floyd. The officer approached George Floyd with his gun drawn. Mr. Floyd was instructed to undo his seatbelt, raise his hands in the air, and place them on the dashboard. He was later apprehended by Officer Chauvin. However, watch how Officer Chauvin is about to get owned through repeated questions that expose discrepancies in his narrative.
You testified that you were the officer who approached the passenger side of the vehicle. You approached George Floyd on May 6th of 2019, is that right?
That's correct, yes.
And you had your gun drawn when you approached Mr. Floyd, isn't that right?
Yes, I pulled it, yes.
And when you approached Mr. Floyd, he said, "Don't shoot me, man, I don't want to get shot," right?
Something like that, yes.
You told him to undo his seatbelt, correct?
That's correct, yes, ma'am.
And he did that, right?
Yes, he did.
And then you said, "Put your hands where I can see them," correct?
Yes.
And then he put his hands in the air?
Yes.
And then you told him to put his hands on the dash, is that right?
That's correct.
And that was when you grabbed his hand and forcibly put it on the dashboard of the vehicle, correct?
Well, and yes.
And then the other officer with you on the other side of the vehicle changed that to put your hands on your head, correct?
That's correct.
And then he put his hands on his head, right?
That's correct, yes.
And there was one officer who said that they were going to tase him, right?
That's what I heard, yes.
And you were yelling pretty loud, correct?
Yes, I was, yes. It escalated real quick.
Some profanity as well, correct?
Yes.
And you had your gun drawn the whole time you were giving commands, right?
Once I started ordering him and he refused to show me his hands, yes, it escalated where I pulled my gun, yes, ma'am.
And he was awake, correct?
What's that, ma'am?
Mr. Floyd was awake. Was he awake during this incident?
Yes.
He was conscious?
Yes.
He didn't appear to be in medical distress to you when you were pulling him out of the car, is that right? He was talking to you, he was standing up, is that right?
I don't know if it was specifically, sometimes he was talking, sometimes he was mumbling. He was incoherent in my mind a lot of the time during there.
But you got him out of the car and you handcuffed him, right?
That's correct, ma'am.
And he stood next to the car, right?
Yes, ma'am.
He asked you not to beat him up, correct?
That's correct, yes.
He was able to walk, right?
Yes, he was.
He continued to talk to you. While you were interacting with Mr. Floyd, he didn't collapse on the ground, correct?
Wait a minute, what was the question? Can you speak up a little louder, ma'am?
While you were interacting with Mr. Floyd, he didn't collapse on the ground, correct?
No, he did not.
Well, the answer is stricken. The objection is sustained.
You were asking questions about what the other officers were doing, correct?
That's correct.
Your attention was focused on Mr. Floyd, correct?
Yes, it was.
And Mr. Floyd didn't drop dead while you were interacting with him, correct?
No.
Thank you. Nothing further.
During the interaction between Officer Chauvin and George Floyd, several discrepancies arose in Officer Chauvin's narrative. These included the use of excessive force despite Mr. Floyd being compliant, the minimization of Mr. Floyd's distress and incoherence, and the dismissal of his repeated pleas for air. Witnesses and body camera footage contradicted Officer Chauvin's account, revealing a prolonged and aggressive restraint that ultimately contributed to Mr. Floyd's death. These inconsistencies were central to the case and were thoroughly examined during the trial. Later, Officer Chauvin was sentenced to 22.5 years in prison for the murder of George Floyd. If you think this was the last evil cop who got instantly owned in the courtroom, then you probably haven't watched this next case.
Okay, bond will be set $10,000 personal bond, no contact with victim, Judge Sherry Midday, Attorney Lee Crispman, and first pretrial November 3rd at 9 a.m.
This is Officer Stoll from the Cleveland Police Department. On October 19, 2022, Officer Brian Stoll and Officer Tyler Munson appeared in court to face multiple charges, including tampering with evidence, assault, and theft. The group faces charges stemming from 2 incidents starting on March 31, 2022, involving a traffic stop in East Cleveland. Body camera footage contradicts claims that the victim hit a police car, showing instead that the victim parked and complied. Officers, including Wood and Stoll, allegedly used excessive force, with Stoll assaulting the victim while Munson assisted in handcuffing him.
Morning, Your Honor.
Morning.
Lee Crispman on behalf of Brad Stoll. Your Honor, he's received an indictment in excess of 24 hours. He waived the reading and are pleaded not guilty.
Okay, bond will be set $10,000 personal bond, no contact with victim, Judge Sherry Midday, Attorney Lee Crispman, and first pretrial November 3rd at 9 a.m.
Thank you.
Case number 674789, James Harris, in the courtroom. Case proceeding by information. Is a pending case on the docket of Judge Brian Corrigan.
I'm sorry.
Both pleaded not guilty to these charges, and the court set a $10,000 bond for each of them. In court, Officer Brian Stoll and Officer Tyler Munson faced damning evidence, including body camera footage that contradicted their claims and exposed their excessive use of force. The footage showed the victim complying with officers and highlighted unjustified actions, such as Officer Stoll assaulting the victim and Munson assisting in handcuffing. The update on this case is unknown. It's shocking to see cops crossing their bounds and then being set right by the court. If you enjoyed this video, make sure to leave a like and subscribe for more. Goodbye